Well, good afternoon, everybody. My name is Andrew Fraser-Urquhart QC. Welcome to the first of our webinars. We're just going to give a few more moments for one or two latecomers to join before we start, before I do formal introductions. Right, good afternoon, everybody. Welcome to the first of FTB's webinar series for 2021. I should just about consider myself in range to say Happy New Year to everybody. Certainly, I know from experience that those of us who are doing dry January will feel that this is only about the 3rd or 4th of the month. It is already the, what is it, 16th, 18th of the month. Good, that's good progress. Welcome to our webinars, described by somebody last year as the new Netflix. That's pushing it a little bit. But myself and Charles Forrest, who is one of the most prominent and active enabler of our junior tenants at FTB, is joining me to give a presentation about the changes to the permitted development regime which have taken place during the course of 2020, partly, as we know, in response to the pandemic, but also partly in response to long-held aims of government policy. First of all, I'll just introduce Charles, formally ask him to come on and say good afternoon to everybody. Charles?
Good afternoon, everyone.
Hello, right. I shall start with slides. We're going to share the presentation duties today, and then we'll take some questions at the end. So we've called this talk "The New Regime and Its Implications." The first thing I think it's useful to do is to just give you the framework of what's actually happened and when in terms of the legislation, because it is actually fiendishly complicated and difficult to follow through. The first statutory instrument bringing about change, and we'll go through in detail what these all mean in a few moments, was the Town and Country Planning Permitted Development and Miscellaneous Amendments England regulations, to give them their full title. We provide the SI number, and then the date, the 23rd of June, you see there, is the date upon which they were promulgated in Parliament, not the date on which they come into force. There was then a tranche of 3 SIs, all put before Parliament, or promulgated by Parliament on the 20th of July last year, and they are called the Permitted Development Amendments number 2, the Permitted Development Amendments number 3, and then the Use Classes Amendment. And we're going to obviously go through the provisions of those in a little bit of detail in a moment or two. And then there was bizarrely named, I think, the Town and Country Planning Permitted Development Amendment England Order. So not recognising that there'd been numbers 1, 2, and 3 ahead of it, it simply called itself the Permitted Amendment Regulations, and that was SI 2020-1243 in November of last year. And then finally, the 6th piece of legislation in this area, albeit it calls itself, reverts to calling itself PED Amendment number 4. I say I've no idea why. And that was 1459, SI 1459, on the 7th of December. So that's the framework you need to look for when you go back, as we're going to say, I'm afraid that you must, to the original text of these regulations, these amendments, just to give you some idea of, or do some of the legwork for you, because it's quite hard to put it all together if you're starting with a blank sheet of paper. Now, what we're going to talk about today are the following. I'm going to talk, first of all, about the changes to permitted development rights, which are items 1, 2, 3, and 6 on the list on my last slide. I'm then going to pass on to Charles, who's going to talk about the use classes element of all this. I'm then going to talk about a couple of the cases in this area which are relevant. The community rights case, which seeks to challenge the lawfulness of the 3 July orders as a whole, and then the Gluck case, which deals with some of the practice of prior approval. Then Charles will come back to consider the very important issue of the minimum space standards, which were in, I think, item number 5 on our list of regulations, and the proposed changes within the use classes order about one's ability to move without planning permission, or at least with a deemed planning permission, between various of the new use classes. And then I'm going to try and sum up and just set out 1 or 2 thoughts about the implications of all this. We're then going to take some questions. There's a couple of things to say about the questions. The first is that we are all obviously tight for time, so we've got to have some sort of cap upon the questions. Also, and I put this in capitals in a way that's not meant to be as aggressive and peremptory as perhaps appears on the screen, but with PD regulations, more than just about any other subject in planning, there really isn't any way around it than to read the regulations for yourself. They're so detailed, there are so many requirements, that if we were to try and go through them all for you this afternoon, we'd be here into the middle of next week. And so what we provide today is very much a summary. And so I do give this very strong piece of advice that we always put out a standard disclaimer, but today more than ever, you must go back, I'm afraid, and just read the source material to make sure you've covered everything off. And the questions, we've got nearly 500 attendees on this webinar. That's wonderful. Thank you very much. But that does mean we might get quite a few questions, and we're going to have to be quite selective in those that we take. And so if yours doesn't get called, apologize. We'll try and respond to the others where we can in other ways, and take it from there. But that's the way we're going to put together today. And so I'm going to start off now by looking first of all at the provisions of the first piece of legislation, the Permitted Development of Miscellaneous Amendments from June of this year. And this all came into force on the 1st of August 2020. And this was not subject to the judicial review challenge to the July orders, the series of 3 July orders. So whatever happens in that, which we'll come back to, this lot will stand. Now, there were a deal of other sort of relatively minor matters, which I'm just going to touch on right at the end. But for our purposes, the thing I'm going to concentrate is on the new Part 20, which is creates a new Part 20 of the GPDO and inserts into that Class A. As we'll see, that Part 20 is further amended by the July orders, but the first new right was for the construction through Class A, the new Class A, of new dwelling houses on top of effectively detached blocks of flats. And that provides for the construction of up to 2 additional stories of new dwelling houses immediately above the highest story of a purpose-built detached block of flats. Now, I summarize there, and I go back to what I said a moment ago about this is very much a summary of the entitlement. But the key point are the addition of 2 additional stories has to be for new dwelling houses, has to be on a block of flats. This is not for a single dwelling house. This is for a building in use as a number of dwelling houses, plural. And that's clearly there in the regs. So the rights only apply if the existing building has 3 or more stories above the ground, the existing building. So it's not for single or 2 stories. Those are 3 or more stories. The eventual building must not exceed 30 meters in height, and the highest part of the roof would not be increased by more than 7 meters. So you can only put on 7 meters, 2 stories in total height. Doesn't apply, surprise, surprise, to a listed building or to a building on Article 2.3 land, which is the various exclusions to GPDO rights, or on a, funnily enough, on a site in a triple SI. So those are the principal exclusions. It's also subject, as are all of these new rights, this is an important matter to which we'll come back in a little bit of detail, to a prior approval process, which has a number of common features, although, again, I'm afraid the boring mantra, read the regs, there are some detailed differences in the prior approval requirements for the various different types of new rights, which I'll touch on where they're significant. But again, you'll need to consult the source material to be sure you've got a comprehensive picture. But in any event, a prior approval process for transport and highway impacts, contamination risks, flooding risks, the external appearance of the building, adequate natural light in all habitable rooms, and the impact on the amenity of the existing building and neighbouring premises, and that specifically includes overlooking privacy and loss of light. So what you can immediately see there, and we'll come back to this, is a pretty comprehensive list of all of the things which might conceivably give rise to an impact in planning terms from the new proposed development. The local planning authority can then refuse the application for prior approval, first of all by reference to the matters I've just touched on the previous page, that pretty comprehensive list, or the list of exclusions which we ran through in outline on a previous slide, or because of a failure by the developer to provide sufficient information. There are requirements as to what information the developer must provide, which we'll just touch upon in a moment. But there's a process for requesting further information with time limits, relatively short time limits, to ensure that the local planning authority has sufficient detail, and if that's not forthcoming, the application can be reviewed on that basis. And then with respect to this class, but not all of the new classes, the local planning authority must have regard to the NPPF when deciding the application, and must, for the purposes of relying on the NPPF, having regard to the NPPF, treat the matter as if it were a planning application. And so the matter I was sort of hinting at, namely that this is in many ways quite similar to a planning application, applies with double force to this class and to the next class we'll consider in a moment, class AA. But it sets out that you've got to have regard to the NPPF. Now, it seems to me that this is really quite important. It's a new feature of these PD rights, and we'll discuss its importance in a moment or two. But be aware that that's there, because that's a very important new aspect of these new rights. The local planning authority has also got the power to impose conditions, subject to them being reasonably related to the subject matter, and you can't have development without the prior approval. That had already been settled in case law, Murphy, but there it is in the regulations. Developers, as part of the prior approval process, have to provide details of the application site, the new dwelling houses, the related works. Just worth pausing there to say that, as well as authorising effectively the operational development, the order specifically authorises certain engineering operations which are needed to bring about the new building work. So those are permitted. Floor plans got to be supplied, and elevations. Development, there's a statutory requirement that they be carried out in accordance with the details authorised, and we're all well aware of the case law, both in general planning in terms of SAGE and specifically applied to the GPDO, which says if you don't do them in accordance with the conditions, you don't have a planning permission at all. There's a provision for consultation with the relevant statutory bodies, Highway and the Environment Agency, and requirements, not just, I've said it in the slide, for notifying members of the public, but actually notifying them and then taking account of the representations that they may make. And there's also a particular stipulation that prior approval must be refused if adequate natural light is not provided to all habitable rooms of the new developments. Again, we'll come on to how the government's thinking has evolved over the course of 2020 about the need to protect the amenity of the residents of these various new developments, which Charles will talk to us about in terms of minimum space standards. But there in that initial legislation was the requirement of adequate natural light for all new developments. So that's the Class A, the new Part 20 with its Class A development of new dwelling houses on top of effectively blocks of flats. Then the first of the July tranche of 3 orders made on the 20th of July, coming into force at the end of August last year. Now, this is one which is subject to legal challenge still, and we'll come back to that. Now, this one adds to Part 1, and this is where it gets even more confusing than usual. It adds to Part 1, which is the development in the curtilage of dwelling houses, the ones that we're all pretty familiar with in terms of doing bits and bobs in the curtilage of a dwelling house. It allows the addition of new stories on existing dwelling houses. That's the first part of the first July 2020 amendments. The second part is to add 4 new classes to the new Part 20, which allows new dwellings above a range of existing buildings, not all dwelling houses, but buildings. So Class AA, Part 1, new stories on existing dwelling house, 4 new classes in Part 20, allowing new dwellings above a range of different types of buildings, including commercial. So the new Class AA in Part 1, in the curtilage of a dwelling house, it allows the enlargement of a single dwelling house by the construction of 2 additional stories where the existing building consists of 2 or more stories. So 2 if you've got 2 or more, otherwise 1 additional story on top of effectively a single story. Now the word story is defined to exclude basement, so a basement doesn't count in your calculation, and it doesn't include any accommodation in the roof. That doesn't count as a story. So if you've got a building with 2 stories and some roof accommodation, and then you put 2 more stories on top, you're still entitled to recreate. This is my opinion. It's an opinion I put on paper in answer to a client. So I'm pretty comfortable with it. You are allowed to recreate that existing roof accommodation because that doesn't count as a story. So when you add in your additional stories, you're still entitled to your accommodation in the roof, in my view, if it's in the identical configuration to what you started with. Not mentioned in the regs, but it seems the only natural reading of the regs themselves. The conditions and exclusions on that exercise of rights, the highest part of the roof. Now, other parts of the order make clear that plant is treated slightly differently in different classes, and this one, it's the highest part of the roof, including the plant, must not exceed an overall height of 18 meters. You can't go up more than 3 meters in a single story, or 7 meters if more than 1 story. So effectively, there's a rule of thumb across the regs that a story is 3.5 meters. The additional story must only be on the principal part of the building. So that's effectively the tallest part and or not a part added by an extension. And this doesn't apply, these rights don't apply if you've already added 1 or more stories by a previous process of extension, whether by these new PD rights or previously, or indeed by granted planning permission some other way. So only if it's the, as it were, the original building. Also worth pointing out that there's a qualifying period. The building must have been built between 1948, when planning control began, and it's the 5th of March 2018. I don't quite know why that date was chosen, but that's the date which all of these PD rights apply to. So very modern buildings don't benefit from these entitlements. Again, prior approval is required. However, the requirements again include the impact of amenity on any adjoining premises and the external appearance of the dwelling house, impacts on air traffic, potentially relevant in areas near airports, and protected vistas, again potentially important, but not with respect to traffic. I think the view is taken that where you're simply adding stories on an existing dwelling house, that's likely to not to add new occupants, but simply to give existing occupants more space, and therefore there isn't likely to be a traffic input. In any event, that's speculation, but if that's the case, then you're not required to consider traffic. And to sort of emphasize that point, the completing building can only be used as a single dwelling house. So this is not the route for adding new flats on top of, or any other use for that matter, on top of an existing single dwelling house. You have to use the thing as a single dwelling house, and then the prior approval procedure is similar, appropriately modified depending on the rights, but it's a prior approval procedure with the same entitlement to consider or requirement to consider conditions, the MPPF on this one, and such matters as effects on amenity and so forth. All of those things have to be considered through the prior approval procedure. So that's the first part. You add to part 1 with a new class AA. You also add to part 20 with what confusingly is first of all called a new class AA. Now in the legislation, it is actually described as uppercase A, uppercase A, so class AA both in uppercase. Just for clarity in making these notes and slides, I've put them in lowercase, and actually, interestingly enough, a trick that was adopted by the divisional court when they considered the challenge to these, but that's why it's in lowercase, not for the reason that it is in that way in the legislation itself. And this is for the addition of up to 2 additional stories of new dwelling houses above a detached 3-story or more building built before the 5th of March 2018 and after planning control started in 48, which is used for retail purposes within classes A1 to A3, offices, betting offices, laundrettes, payday loan shop, which are collectively called commercial uses, or a mixture, including mixed buildings which have these commercial uses plus dwelling houses, so a shop on the ground floor and then 2 floors of residential accommodation. So if you've got that kind of building, you can add up to 2 stories. Total height of the building can't be 30 meters or more than 30 meters. And there is a prior approval process there. And that one additionally requires prior approval based on the noise effects and the effect on trade in the nearby vicinity. Class AB, similar type of scenario. This is an additional story on a single story building, or 2 stories, up to 2 stories above a terraced building, which is in use for the same commercial purposes as Class AA. That should be Class A little a. I have to follow my notation. Apologies. So what this is effectively saying is where you've got a terraced building in those commercial uses, you can put 2 stories on a 2-story building, or a single story on a single story terraced building, with those caveats. Class AC, this is in the new Part 20, the new Class AC, which is allowing the addition of stories to single dwelling terrace houses. So this is again single story on a single story to 2 stories on 2-story or more building where it's a terrace building built before the 5th of March 18 in use as a single dwelling. And this is not the extension to form a single household. This is to put new accommodation, new separate units on top of a terraced building. Overall height 18 meters, prior approval needed. And then Class AD, which is the 4th of the new additions to Part 20. 1 additional story of new dwelling houses for a single story, 2 stories above a detached single dwelling. So the last AC was terraced, AD is detached single dwellings. Again, not required to be a single dwelling house at the end of it all. So this is addition of new units, 18-meter height, prior approval process as before. So those are the 4 in outline, and I do stress in outline, read the regs yourself for all of the ins and outs. Those are the 4 new classes to Part 20 added by the 1st of the July 20 orders. The 2nd of the July 20 orders, again in force on the 31st of August. This adds to Part 20. So Part 20 now consists of 6 categories, 6 classes. This adds a new Class ZA to Part 20. And this provides for the demolition of either an existing single purpose block of flats or a single detached building with use rights within the B1 class, and its replacement by either a purpose-built block of flats or a detached dwelling house. So this is a demolish something and rebuild. The building must have been constructed not 2018 as all the others, but before the 1st of January 1990. Relatively small footprint. Mustn't have a height exceeding 18 meters. You can't bring down whole blocks of flats with this. And it must have been, and this is the key one, excuse me, vacant for at least 6 months immediately before the application for prior approval. So it's providing for the demolition and reconstruction with dwelling houses of either vacant blocks of flats or vacant commercial premises. Doesn't apply, again, unsurprisingly, to a listed building, perhaps more restrictively to an unlisted building in a conservation area. So in those cases, in order for normal planning and listed and heritage policies to apply, clearly you need a separate planning and indeed listed building in appropriate cases application. The requirements with respect to the new building, the footprint of the new building mustn't fall outside the footprint of the old. It mustn't exceed more than 7 meters of increase or an overall height of 18 meters, whichever's lower. And you can't add more than 2 stories. And again, there's a prior approval process, but this time, obviously, given the nature of demolition works, you have to consider heritage, you have to consider archaeology, the design, not just of the external appearance, but the design of the building as a whole, and matters of landscaping. It's clearly a wider range of things to consider on prior approval where you're demolishing and putting up a new building. So that is the new ZA, one of the 6 classes. You've got ZA, you've got AA, and then you've got the 4 additions to Part 20, which I've been through, and I won't go through again. They're all there in outline on the slides. Just now, really cementing some of the details. The PDF number 4 regulations, which is actually the 6th in the sequence, enacted in December, in force at the end of the year. It adds fire safety of external walls to the list of prior approvals for A and AA within Class 1. So these are the new heights on already high buildings for obvious reasons. Obviously, post Grenfell, it's perhaps slightly surprising this wasn't considered appropriate when the matters were first enacted, but that little lacuna has been closed, albeit it's not been done retrospectively. It's only for those prior approvals applications submitted after the 20th of December. So anything put in during the course of the autumn is not caught by these requirements. And then just finally, before I hand over to Charles to talk about use classes, just be aware the reform of PD rights has been not just about additional of units for residential, but various other matters. Just a very brief outline list, and this is absolutely not to be quoted, but just so you're aware of some of the range of other matters. Temporary periods of time for use of land have been extended to 56 days. Local authorities have been given the right to hold markets, although obviously with lockdown, that's not really a goer at the moment. The rights for all restaurants and so forth to serve takeaway food, that has been granted and indeed continued. And obviously with lockdown, that's of fundamental importance, certainly to some of us. The prevention of demolishing venues. One of the issues that has arisen with the lockdown is the non-use of such things as theatres and concert halls, and to protect against any sort of vulture developers who might think, well, there's a killing to be made here while this thing isn't in use. The normal rights, PD rights of demolition, have been taken away in respect to certain classes of that kind of performance-related venue, and a wide range of emergency-related powers related to the COVID emergency, enabling the Crown to do various things. So those are the fundamental PD right changes. I'll now pass over to Charles, who is going to take us through the use classes elements of the changes, particularly in the July trial. So I will stop sharing. Charles will start sharing and take over. Charles.
Thank you, Afu. I hope all of you can now see my screen and can now see my slides on your screens. As Afu said, I'll first talk about the changes last year to the use classes order. Some of you will already be familiar with those, particularly those on the sort of sharp end of things, but they're important to talk about of themselves. big changes were wrought by them, but also they provide context for what I'm going to talk about second, after Afu's second talk, which is about the proposed changes by the government to the GPDO, so that under PD rights one can change use from this new Class E, this very wide Class E, to C3 residential, and that's what I'm going to be talking about second. But first, in relation to the changes to the use classes order, it's important just to go through some basics, which will be familiar to all of you, but are important to think about when we're talking about the use classes order, and that's going back to section 55. Obviously, development includes material change of use of land. Development requires planning permission. There is a carve out to section 55 development, that's in section 55 subsection 2. And one of the carve outs is that it will not be development, and therefore there's no need for planning permission. It will not be development to use land for another purpose within the same use class in classes prescribed by the Secretary of State. And it's the Use Classes Order 1987 where we find those prescribed use classes from the Secretary of State. So it's not like permitted development where certain changes of use are development, but permission is given at a national level beforehand. And it's not like permitted development where obviously Article 4 directions can be made and there are prior approval applications which can be required. Changes of use within a class in the use classes development order is not development at all. So that's just important just to bear in mind when we're talking about this issue. So what were the changes that were brought about last year? And this is a table, the next 3 slides have this table on, and it's in yellow, which are the key changes on the right-hand column, and just summarising the changes that were made. And it's essentially the creation of this new wide Class E. And Class A, the previous Class A, that's been revoked. A1 to A3 has been moved in to this new wide Class E. That's subject to an exception in relation to A1. This is the top part of the table, where a shop no larger than 280 square metres, mostly selling essential goods, including food, and at least 1 kilometre away from another similar shop. That isn't in Class E, that's in another new class, which I'm going to be talking about, which is F.2. Just to give you some bearings, that 280 square metres, that corresponds with the footage in the Sunday Trading Act. So it would be the type of shop, supermarket or convenience store, which is open for longer than 6 hours on a Sunday. That's the kind of shop which could, in principle, fall within this exception, subject to that 1 kilometre away from another similar shop. And obviously in rural areas that will be, more likely, but in more urban areas it will be less likely. So you can see there's a lot of liberalisation with the revocation of Class A there. A4 and A5 were not transposed into the new Class E. They've both been moved into sui generis. Class B1 has been revoked, and that has been also moved into the Class E. This slide, unlike the previous one, is really more about continuity. So you can see there B2 and B8, they remain unchanged following the new law, as does Class C, hotels, residential institutions, dwelling houses, HMOs. They have all stayed the same. D1 has been split up. Clinics, health centres and creches, they also go in to the new wide Class E. Non-residential institutions in the form of schools, education, training centres, museums, they have gone into a new class F1, which relates to learning and non-residential institutions. This is the final slide showing the table, and D2, like D1, has sort of been split up and divvied into various different classes. Cinemas, concert halls, bingo halls, they've gone into sui generis. So similar to what Afi was talking about earlier, about these are purposes, these are uses which have been threatened financially by the effects of COVID, and by moving them into sui generis, it would make it, in theory, much more difficult to move from that use, at least under the use classes order. Gyms, indoor recreation centres, that's also been moved into the new wider class E. And then finally, you see these two, which are both F.2. So this is the same class that those small essential shops were in. And F.2 is the local community uses. So you can see they're halls or meeting places for the principal use of the local community, and also swimming baths, skating rinks, and outdoor sports or recreations, not involving motorised vehicles or firearms. They've gone into the new F2 class, and then sui generis remains largely the same, with the addition of those uses which were covered on the last slide. So that's a very quick run through of really the quite radical changes that were brought about last year through the amendment of the use classes order. As Afu said, some of these are brought about due to the pandemic, but some of them are also more pre-existing aims, all about saving the high street and things like that. And I'll come on to that a bit later. So this slide relates to the application of the new law and the transitional arrangements, because these are very important. The changes apply in all of England. So it's not just about town centres. Often when we talk about saving the high street, we think about sort of in large towns, perhaps outside of London, in the middle of large towns and small cities that need saving. It will, of course, apply to them just as much as it applies to large urban areas such as London, but it also applies to more rural areas. And that's a really important point. In respect of Wales, they will still operate under the old law. Now, the amendments have been in force since the 1st of September 2020. There has been some confusion caused because a lot of, these changes have been coming quickly. They've been coming in sort of dribs and drabs. And that's led to some sloppy drafting in some case. And that's certainly the case in the regulations which brought about these amendments. And in Regulation 7, it appears to imply that actually only some of these amendments came into force on the 1st of September 2020. But it appears that's really a declaratory provision, and it's incorrect. All these amendments have come into force on the 1st of September. As before, it applies to land and buildings. Obviously, some uses only apply to buildings, but it applies to land and buildings which are being used lawfully and or with immunity as well. So if you're operating unlawfully, you can't benefit from these new liberalised use change rights, just like you couldn't beforehand. And the use needs to be occurring doesn't need to be occurring on the ground at the time of the change, but there must have been some sort of previous sufficient use, more than token physical use, to benefit from these rights under the use classes order. So if a use has been abandoned, or if, for example, you only have a mere legal entitlement to the use, for example, you have an unimplemented planning permission, you can't benefit from these just as before. It's about having a physical user at the time, or at least more than token in the past. And again, as before, if the land is not being used, it will need to be brought into use, either through the grant of a planning permission or the implementation of an already granted planning permission before you can benefit from the use class order. So those are exactly the same as before, but they should be remembered, because it often comes up when you say, well, you know, I want to benefit from some of these things, can I? And that will certainly be happening more now that the system has been liberalised so much more. The old use classes apply to planning applications submitted before the 1st of September 2020. That's really relevant now for things like planning appeals. And the old use classes also apply to any SIL charging schedule published prior to the 1st of September 2020, where the SIL charging schedule sets out different rates by reference to different uses in the UCO. Where that schedule dates from prior to the 1st of September, the old law will apply. The final point on the slide is very important because that applies to the GPDO. Until the 31st of July 2021, so for the next 6 months or so, the old use classes will still apply. So, you know, B1 to C3, something like that, that will still apply for the next 6 months. That includes prior approval applications, that includes Article 4 directions made before the 1st of September, and indeed the making, modifying and revocation of Article 4 directions. The old use classes will all still apply, but that will, from the 1st of August, when there are wider changes, which I'll talk about some of them, that's when the amendments will be made. And they're also, the old use classes apply for certain miscellaneous things, such as Article 2 of the DMPO. So it's important, we can't go through all of the different ones, but it's important to really check that to make sure that you're on top of the transitional arrangements. So just before I hand back to Afu, just a point about the effects of these changes, because they are really quite radical. There's certainly more flexibility, that almost goes without saying. Land could be more quickly and easily repurposed, which is important for saving the high street, which was deteriorating even before COVID, and that has really been accelerated over the last year or so. So there's been flexibility by the creation of these new classes, including Class E. Another important thing is that Class E allows for a mix of uses, because it provides for the use or part use for all or any part of the purposes set out therein. So this recognises that buildings, particularly nowadays, may be put to a number of different uses, either concurrently or consecutively. So, you know, you have pop-ups going up and things like that. And so as long as those things are all within the same class, and it may well often be Class E has the flexibility there to regulate and to allow the different uses within the same class in different parts of the site. So you have that great increase in flexibility. However, obviously you also have the giving away of a lot of control by local planning authorities, and there's no question that is what has happened, and that's what will happen. Local planning authorities have lost a lot of ability to decide whether a change of use is in the public benefit, whether it would cause harm. Local planning authorities have lost the ability to control the mix and ratio of uses. And so in terms of, well, what constraints are left, certainly not as many as there were before. Okay, you have the existing conditions, planning conditions and Section 106 obligations, which exclude the use classes order. Although obviously it's not development, local planning authorities have always been able to impose conditions saying you can't, although it's not development, you can't change use within the same class. There are many, many planning permissions out there which have that kind of condition. They will continue to bite. Also the fact that if any change of use in order to, say, go from office to restaurant or something like that, if that needs external works, planning permission will be required for that. It's quite likely that a lot of this control and regulation may well be moved into the licensing sphere. Licensing and planning are obviously separate regimes. There is some overlap though, and if we're talking about things being changed into premises serving late night refreshment or alcohol or something like that, well, the burden of regulation might fall more on the licensing system now rather than the planning system. And finally, private law, many leases will have user restrictions and many buildings will have restrictive covenants. And they obviously will be a constraint, but quite reasonably people will say, well, that's not good enough because those things don't protect the public realm and those things can be changed. So it'll be interesting to see what happens there. Other effects include obviously more Section 73 applications as people try to discharge some of these conditions which restrict or exclude the use classes order. More Article 4 directions, and they're not relevant for now, but obviously when the new use classes are applied to the GPDO, we may well see more Article 4 directions to try and stop the kind of changes from Class E to C3, for example. On new consents that might be granted, we'll see, I suspect, more conditions excluding the use classes order. And finally, these 2 points, which I'll deal with very briefly looking at the time, but there may well be difficulties in terms of valuation because it's difficult to value assets with all the different uses that could potentially now apply to it. And the infrastructure levy, which is the new SIL, the proposed new SIL, well, that will apparently be linked to development value. It's difficult to know what that development value is now that the use classes order regime has been so liberalised. And finally, there is a lot to say on policy, but just one takeaway is that when you have in the NPPF, Section 7, which talks about restricting town centre uses to the town centre, and many local plan policies will have retail hierarchies and all that kind of thing. Can people get around the sequential test in the NPPF by essentially having a gym use or a creche use in a non-town centre area? And then once they've got that permission, then switching to a town centre use, for example, a restaurant or something like that. Obviously, that's subject to conditions that might be imposed on the original grant of permission. But these are all, questions which will be asked and hopefully answered over the next few months and years. But it looks like the effects of this, could be quite dramatic. Anyway, right, that's all from me for now. I'll pass back to you, Afi.
Thank you, Charles. I have just an eye on the clock now, so come on. We will need to make some progress here. 2 cases to tell you about of differing types, but both important to the operation of the new regime. The first is the Rights Community Action Pressure Group case, which was a challenge to the 3 July 2020 orders, 2, 3, and 4 in my scheme. The use classes redefinition order, and then the order relating to demolition, and the order relating to effectively building on top of existing buildings to add residential units. Now, the importance of this case really lies in two matters. The first is to note that it's been decided in favour of the Secretary of State, so the initial challenge to the lawfulness of those orders has failed. But because it's under appeal to the Court of Appeal, and of course, if upheld, could bring the whole system crashing down, or at the very least, it could require extensive reappraisal and reanalysis before the changes could become effective again. It's just worth understanding a little bit of where it went and where it might just go. It's also important to note that, as a matter of procedure, that the claim was held, although it was a judicial review, it was held through what's called a rolled up hearing, which is where the permission stage, obviously you've got to have permission for judicial review, and the substantive hearing stage are done all in one hit. It's sometimes necessary procedurally for reasons of time or whatever to do it that way. But it does mean that the Court of Appeal is in effect dealing with two things. It's dealing with those bits of the case, as here, where the court said there wasn't even an arguable case to justify a grant of permission, and those where the court said, yes, there was an arguable case, but we're just not agreeing with it substantively. And so just be aware of that little wrinkle on the situation as the case goes up to the Court of Appeal. 3 grounds of challenge. First of all, that the orders should have been subjected to a strategic environmental assessment within the directive and regulations on the basis of them being effectively a plan or project which set the framework for development consent. Secondly, that they failed to have or failed to comply with the public sector equality duty. And thirdly, failure to have due regard to the consultation exercise, it being particularly noted that there was a very strong volume of objection to a number of these proposals. In some ways, I think the most legally interesting and therefore the one that the Court of Appeal is perhaps most likely to interfere with is on the grounds of strategic environmental assessment. It's important to note, first of all, that the use classes order, because this challenge was dealing with 3 orders, was taken out of the equation because the court held, and I think probably fairly unimpeachably, that the use classes orders, all they do is define whether there is a need for planning permission. They can't really, on any view, set a framework for deciding how those consents are given. And more problematically, the court held that the permitted development orders were not a framework for future development. They didn't, as a local plan, for example, would do, set out where development is going to go and what form it's going to take. It's simply a mechanism by which consent is granted. And it also was suggested by the court that there wasn't a significant body of criteria about how to exercise the power to grant development consent, which you would expect from, as it were, a framework document. Now, I have some doubts about those findings. I can't put any higher than that, because it is obviously clear that the PD orders do provide a decision-making framework. They set out a list of things for which permission is to be granted, and set out a mechanism by which that permission is to be put into effect through the very extensive prior approval proposals, and they set out a set of criteria. And I think it is just worth noting, I won't say more than this in this session, but just note that there are some issues with the court's decision, I think, and it's not beyond the bounds of possibility that the Court of Appeal might take a different view, which would obviously have pretty radical impacts. And one point that the Divisional Court did make was that this line of logic that the claimants unsuccessfully deployed, but which the Court of Appeal might go for, is something which would have wider implications, not just for permitted development rights, but other forms of deemed consent type environments, possibly in the advertising context, possibly in many others. And so there might be an unwillingness in the court to set forward a decision which would have that kind of extensive input and effect. The second and third issues can be dealt with rather more quickly. Public sector equality duty wasn't even arguable. The duty, as we know, is only to have due regard to the various equality objectives, and it was said on the facts that there were sufficient assessments done to meet that standard. And then with respect to consultation, it was suggested that there had been a consultation paper pre-COVID, because we said that these were partly a response to COVID, but partly in response to longer held policy objections. There had been a consultation paper, notwithstanding the volume of objections set out that way, that the minister was entitled to form a view which was different from the majority of the consultation responses. There was also a promise given, or a suggestion had been made, promises perhaps put it too strongly, that there would be a technical consultation, and there such as to create effectively legitimate expectation that there would be a consultation on those technical matters. But the court held that there were sufficient grounds, particularly given the COVID situation, to depart from the promise to do that. And so whilst there was a legitimate expectation, it was suggested that that was departed from properly and lawfully. But the court did say that that point at least was arguable. So that goes up, as it were, to the Court of Appeal as the point which is held by the court below to be arguable. The rest of it wasn't. So it's really the strategic environmental assessment points that you need to just be aware of as a possibility for this lot being binned by the Court of Appeal at some relatively soon future date. So that's the community rights action case. Perhaps in a more mundane way, but probably more practical importance, certainly to local planning authorities, is the issue of whether or not there is power to extend the period for prior approval. Of course, local planning authorities have a slight gun to their heads in that if prior approval isn't given within a relevant timescale, then it is, if it isn't contested within a relevant timescale, usually 56 days, it is deemed to be given, and the development just proceeds. And the court was faced with a situation where there was an argument in slightly dubious factual circumstances, frankly, where it was suggested by a developer that the local authority had missed the boat. The court held that, in fact, there was a power to extend the time for prior approval by agreement, that the principle of and the duration of any extension had to be agreed. So it's not just a question of agreeing that you will have an extension. It has to be agreed for how long. It has to be specific in that regard. So just to generalize, we're just going to extend the time. That doesn't work. It has to be a specific agreement, which a sensible developer is only going to give for some reason, probably relating to the provision of information. In the Gluck case, it was about a noise report. It's only given for a particular reason, and it must be for a set duration. However, slightly oddly perhaps, although the statutory words say that there is a power to extend in writing, in fact, the agreement may be made orally. So the agreement as to the fact there's going to be an extension and for how long can be recorded, but only later recorded in writing, evidenced in writing. So it doesn't actually have to be a signed written agreement, just simply a written record of a verbal agreement. And that written record needs to come from only one party. Now, clearly, if there's a dispute of evidence as to whether or not an oral agreement was made, then that's one thing. But where it's agreed between the parties that they agreed orally on the fact of and the duration of an extension, it only needs to be recorded, and that can be subsequently by one party. So it's obviously quite a loose and purposive interpretation of the regulations, and it does give a reasonable degree of flexibility to local planning authorities and developers if for some reason the time begins to become a factor. It doesn't provide an open door for local planning authorities to spin the process out, or indeed for developers to do so, but particularly for local planning authorities. But it does at least provide a mechanism for sensible disposal of prior approval applications, and gives appropriate time when needed for relevant information to be collected and provided by a developer. So those are just two little cases which are probably important to know about in the context of this general discussion of the new PD rights. I'm now going to go back to Charles to talk about space standards and the possible rights to move between the new use classes, before finally I'll sum up just some of the wider implications of what we're seeing today. Charles.
Yeah, thanks, Safi. I'm conscious of the time, so I'll try and do this as quickly as I can. The second issue I'm going to be talking about is 2A, proposed new permissive development right for the change of use from Class E to C3. Forgive me, I'm just having some. Great. So there's currently a consultation ongoing until the 28th of January 2021 as part of the Supporting Housing Delivery and Public Service Infrastructure consultation. And one of the things they're consulting on is a new permitted development right for the change of use from Class E, which is that very wide class that I was talking about earlier on in the talk, which is a commercial, business and service class, to C3 residential. This, as with those previous changes I was talking about, will only apply in England, and it's intended to come into effect on the 1st of August. And that's no accident, because part of this proposed permitted development right is transposing and therefore also consolidating pre-existing PD rights to change the use to C3 under the GPDO. So there are already various change of use rights to C3 from shops, financial and professional services, offices, and they need to be updated, transposed into the new law. So there was always going to be a change at this point. But the point is that because Class E is so wide, there are substantively new permitted development rights to change from various uses now in Class E to C3 residential use. And these are the new substantive rights which would be introduced if this consultation is carried through into law, and it would allow for the whole or part of buildings used as cafes and restaurants, health centres, clinics, creches and nurseries, day centres and indoor leisure facilities such as gyms. It would allow buildings in those uses to, in principle, benefit from the change of use to C3 residential, which would be a very large change and liberalisation of uses. Another key point is that there would be no size limit on the buildings that can benefit from this proposed new permitted development right. As the law currently is, as the GPDO currently is under the old law, I believe that's the case with offices, but not for other rights to change to C3. There is a sort of square meterage limit on the buildings that can benefit from these permitted development rights. under this new right, class E to C3, there would be, if the consultation is carried through, no size limit on buildings. And obviously that, in principle, the change would have a large effect. But if you're having very large buildings that are being converted on a very large scale, a lot of units being converted into C3, obviously that is a big change if you have that number of units coming on through the permitted development right system. Now, similar to existing change of use to C3 PD rights, this proposed PD right would not apply to various categories of land, triple SIs, listed buildings and their curtilage, sites that are or contain a scheduled monument, safety hazard areas, military explosive storage areas, and sites subject to an agricultural tenancy. And it also wouldn't apply to Article 2.3 land, as you would expect, so AOMB, Section 43, Subsection 3, WCA 1981 land, and national parks, the Broads, and World Heritage Sites. Another innovation is that, as currently proposed, this proposed right would apply in conservation areas. And part of the justification for that, so the government says, is that, well, many conservation areas are, high streets themselves. And so if we exclude conservation areas, then that's going to severely inhibit this proposed right. So as proposed, it would apply in conservation area, but that would be subject to the prior approval process, taking into account the impact of the loss of the ground floor use to residential. So if you have a nice conservation area with on the ground floor shop and retail all along, that would be part of the prior approval process of, well, how much harm would be caused by losing that ground floor sort of frontage, and can that be mitigated, for example, in any way? And I spoke about prior approval, and there would obviously be a prior approval process for this proposed right. The considerations would be similar to existing PD change of use to C3 rights. It would be flooding, transport, contamination, exactly what you'd expect. Other considerations relevant for that prior approval process would be to ensure appropriate living conditions for future occupiers. They'd consider the impact of noise from existing commercial premises. Certainly that would be important initially if you have continuing commercial activity going on around this new residential use, and that's certainly the government's intention. Obviously, they don't want all of these areas just to be converted into residential. They still want a mix of use, and so it's envisaged that there would be continuing commercial activity going on around any new C3 use, and the prior approval process would take into account the impact of noise from that. Afu spoke about, in a different context, the provision of adequate natural light in habitable rooms, and this is a recent change that's been brought in, and that would be relevant to the prior approval process, as would fire safety. Finally, to ensure that new homes are in suitable locations, other considerations to be taken into account would be the impact on the intended occupiers from the introduction of C3 use in an area the authority considers as important for heavy industry and waste management. Now, in terms of considerations which would not be relevant, it would be things like impact on other nearby commercial uses, impact on neighbours, so that would not be taken into account in the prior approval process. And at the bottom, there is the information that has to accompany any prior approval application as is currently proposed. Obviously, floor plans showing dimensions, information necessary to support those considerations I just spoke about, and also the appropriate fee, which is, as currently proposed, £96 per dwelling, capped at 4,800, and I think that's capped at a level of 50. So there's no limit on the size of the buildings that can be converted to C3 use, but there is this cap on the fee to be paid, which is a maximum of 50 times 96. And finally, just dealing with the nationally described minimum space standards, and dwellings under this new permitted development right will have to meet the new nationally described minimum space standards, which is based on the gross internal floor area for all new permitted developments dwellings in England. This came into force, or was promulgated, on the 3rd of December, and transitional arrangements mean it applies to any dwelling for which an application for prior approval is submitted on or after 6th of April 2021. So from then on, any dwelling created under permitted development rights would have to comply with these nationally described minimum space standards. I'm obviously not going to go through those standards because it's very technical and very long, but there's a link there to those standards. Many of you will already be aware of them because they've been in place for a number of years. The difference now is that for the purposes of permitted development rights, they will be mandatory for any dwellings created, which I'm sure many people will welcome, because obviously there was a good case for applying these standards beforehand, and because there has been some abuse of the office to C3 over the last sort of 7 years or so. And I think the government's intention is that by making these space standards mandatory in relation to permitted development dwellings, it will help sharpen perhaps some of the sharp practices that might be used in taking advantage of this new flexibility. So look at the time, I should probably stop there and pass back to Afu, who's going to round things up.
Thank you, Charles. Yes, we are just slightly running short of time. Before I finish, I'm just going to say that we've had one or two questions, some very technical, some we've answered as we've gone along on the type facility. What we'll do is we will download those as we're able from the feed, and we'll come back to people with answers to their questions after we finish the session, rather than having it run over for everybody. I'm just now going to finish with some thoughts as to what some of the wider implications might be, some of the wider issues that might come about. Now, the first, when the slides come to life, I mean, the first is to notice that, of course, all of these rights, which are very extensive, come with a pretty strict prior approval regime. It's worth noting that in pretty much most cases, although the details do differ, and again, it's back to the age-old mantra, I'm afraid, of read the stuff, read the regs in detail. But I mean, is it just a case of giving with one hand and taking away with the other? Because local planning authorities will clearly retain a good deal of control through the prior approval regime. Matters such as amenity, impact on neighbours, traffic, etc., are often at the heart of the prior approval situation. And so many developments which might fall within the conditions of the new PD rights might not get prior approval. But it is just worth noting, before that's taken as too much of a block on what happens, is that there are a couple of factors which do have to be borne in mind. The first is this: given that the government has given these new rights, and clearly there's a policy objective of quickly and speedily increasing the delivery of residential units in the areas where the new regs bite, and the type of building already scenarios which exist. I would have thought that it's going to be a brave local planning authority that completely disregards that policy objective when coming to its views about prior approval. If it is to be the case that Parliament intends people to have the right to build an additional 2 stories, is a local planning authority going to have an unfettered right to say, well, actually, we don't like the fact that that makes the building a taller building which has more impact? I must always remember that change is not the same as adverse impact. And so I think that that is going to be something which is going to be argued about a lot and probably litigated. The second thing to bear in mind is that a couple of the classes, not all, not the 4 additions to Part 20, but the new ones in Part 1 and the Class AA in Part 20, they do have or make a requirement that the local planning authority has regard to the NPPF when coming to its decision on prior approvals, treating the matter as if it were a planning application. And it seems to me that if that's the case, then it does bring into play the possibility of the tilted balance. As we're all familiar with now, I'm sure, the requirement that permission be granted unless the thing demonstrably causes significant harm, significantly and demonstrably. There we are, the harm significantly and demonstrably outweighing the benefit. That test may come into prior approval consideration. So can one say that the effect, say, on the character of the building is such as to significantly and demonstrably outweigh the benefit from the new residential units? Don't know, but it's a very interesting new angle on these PD rights, and I think we would be very well to have regard to that. Obviously, one will have to have regard to it and evidence that one's had regard to it when making prior approval decisions, but it does provide where the tilted balance may be engaged, obviously particularly if there's not a 5-year land supply in the area. It does provide a really important new way of decision making. Just thinking a little bit about enforcement, many of you will know what I call the Ahmed Principle, and I love it because I was in the Court of Appeal case that made it, which says that if you have an enforcement appeal and you've got a Ground A appeal running, the inspector must have regard to some smaller change that might solve the planning problem. Given that there are many ways now in which additional floors are put onto new buildings and modifications of this sort, is that going to mean that there's a whole new line of argument for people running enforcement appeals to say, well, I'm going to rely on the Ahmed Principle and the new PD rights to say actually that this minor change shouldn't all be knocked down and I should be allowed to keep most of it? Are we going to find, as vacant units are demolished and units put on, that there's going to be a loss of affordable housing? We will obviously see a lot of residential development coming forward which isn't subject to affordable housing policies, and so there might be a decreased ability to secure affordable housing. And in fact, the court in the Rights Community Action case did actually recognise this as a possible trigger of the public sector equality duty. So it's recognised by the courts as a possibility. Or is in fact the opposite going to be the case, that the minimum standards when they come in will simply be regarded as a ceiling and not as it were a minimum, and people will simply build a whole series of units at the minimum possible space, and that might lead to some assistance with affordability. Doesn't know, but these are just some thoughts as to how this new regime may work. And I think the real takeaway here is that the prior approval regime is likely to have quite a braking effect on things actually being developed under this regime. And what will be really interesting to see is how the mere existence of the new rights, and for those cases where the MPPF has to be considered, where that new requirement to consider national planning policy, treat the thing as a planning application with all the positive things in favour of a grant as well as the things pushing away from a grant of prior approval, will actually cause this regime to act in reality. So it may be the revolution in town life, townscapes that we think it might be, but it could just as easily, frankly, be a grand damp squib of lots of prior approval refusals, and speaking from the barrister's perspective, lots hopefully of prior approval appeals needing inquiries. But that is our cri de coeur for another day. I hope that's been useful. It's certainly a technical area. Well, I do say for the last time, I promise it'll be the last time, make sure you read the regulations, because that's really where the answers mostly are, and you can't do without it. But I hope that general introduction has been helpful. Charles, thank you very much indeed for your contribution, interesting and authoritative as ever. And everyone else, good afternoon. Thank you very much for your attendance.
Good afternoon. Thank you.